Fantastic. Thank you. All right. Good evening, everyone. Thank you for joining today. My name is Cesar. I'm from the Female Dentist, and today we have the webinar Employment Law Update for Dental Practices, What You Need to Know in 2026. We're pleased to be joined by MFA from the HR department, who will be sharing key law updates in this new law that is going to be in 2026. Just a quick reminder for if anyone here is not a member of the Female Dentist, if you become a member, you can rewatch this webinar in your members hub on the website. So that's all that I want to say. So Emma is now on you now. Thank you.
Wonderful. What I'll do, I'll just share my slides and make sure everybody can see those. Great. Hopefully those are now showing. Just give me a shout if not. Good evening, everyone.
All good.
Great. Thanks so much. Good evening, everyone. It's great to be here this evening. There's a lot to talk about when it comes to HR and employment law. At the moment, it's going to be a busy year ahead. So what I wanted to focus on this evening, got quite a lot of content on the slides. So apologies in advance for cramming a lot in, but I'm trying to make it as useful as possible for you guys. We're going to cover the Employment Rights Act 2025. So this is the bit of legislation that was passed just before Christmas. Little Christmas gift for all of us who are trying to run busy businesses. So what I want to talk about is what to actually expect. So this is the agenda for this evening. What actually is the Employment Rights Act? What are the key changes coming in? There's a lot of them coming in over the course of this year and next. So we'll focus mainly on this year, but I will give you a heads up as to what's coming next year as well. We will then have a look at that timeline because there's different things being implemented at different times. So it's good to know. Now, I will just say these things are subject to change whilst the law is passed. What isn't fully set in stone is that timeline. So everything is what the government has said as of today. Just keep an eye out for updates because, as we know, government can change their minds. So let's all just keep ahead of that. But importantly, towards the end of the session, we'll look at what you can actually do to prepare. So this isn't about being worried and being frightened of what's happening and the volume of changes that's coming in. This is about just being aware and understanding actually, but what can we do to be more in control of what's happening rather than kind of just being taken along with these changes, because they are going to have an impact on every business, and in my opinion, small businesses are going to have the biggest impact of all. So in terms of what the Employment Rights Act actually is, there already was an Employment Rights Act, there still is, the Employment Rights Act 1996, quite an old bit of legislation, which is the fundamental bit of law that gives out the employment rights that workers have. That is obviously supplemented by other bits of law like the Equality Act, national minimum wage legislation and things like that. So now you probably heard a lot of talks over the last 2 years about the Employment Rights Bill. That was what Labour government proposed when they got into power. It was all this kind of big talk about the first 100 days and this is what we're going to do. Obviously, they didn't do it in the first 100 days because that's impossible. So here we are. We have now got the Employment Rights Act 2025, which is what passed on the 18th of December, week before Christmas. And this is that implementation of the quotation Make Work Pay manifesto pledge. The focus, as we would expect from a Labour government, is all about enhancing workers' rights, protecting employees. There's not so much consideration for business, unfortunately. We tend to see it change. If there's another government in the future, we will see things go back. So it's just unfortunate for now that we've had to, as businesses, go along with this and make sure we're enforcing the rights as much as the bigger organisations. So this bit of legislation doesn't replace the Employment Rights Act 1996. That's still very much the core bit of law. This is almost an addition. It amends some parts of the old Employment Rights Act that we're going to talk about today. But both bits of legislation are effectively going to sit alongside one another. So key changes. This is a very quick run through. I'm going to do slide by slide. So I'm not expecting you to take much away from this slide, but just a very quick overview. Sick pay is changing. We're going to have sick pay eligibility from day one of sickness absence. Lots of trade union changes coming in. We've seen very reduced amounts of trade union activity probably over the last 15 years. So there's going to be quite a lot of shift there. Banning of fire and rehire, we'll talk about that in more detail in case you're not sure what that is. Increased obligations around preventing harassment of your staff. That's something that's already been kind of making waves in the law from about not 2 years ago, but 18 months ago, when the law changed around sexual harassment. We're going to just see more of that nature in terms of the Employment Rights Act. Extending tribunal limits, basically making it easier for employees to bring tribunal claims. So as I say, this isn't necessarily great news for business. You might know that Labour were proposing a day one unfair dismissal protection. It was that every worker from the first day of their employment would be able to bring an unfair dismissal claim if they were dismissed. I say unfair, that's in the legal sense, not in the moral sense. It's very easy for an employee to say that a dismissal was legally unfair. So that proposed change of day one unfair dismissal protection was a real worry. So much of a worry that they've had to turn round on that. Now we've ended up settling on a 6-month qualifying period. Currently, that qualifying period is 2 years. So we've scrapped day one, we've got 6 months. So it's better for employers that we've got 6 months. Still a bit of a challenge, I think. But again, we'll talk about that in more detail shortly. We also have some changes coming in later down the line around 0 hours and agency worker contracts. I'm not sure how many of you use those type of contracts, but we will touch on that just in case it's applicable to anyone here or anyone watching the recording. And we will also see extension of some other rights, like bereavement leave, beyond who it currently applies to. So we'll touch on that again. That's more of a later down the line change. So to give you a little bit of an overview of that timeline, we have this set out, and again, I'll recap on this on the individual slide. So this is the roadmap that the government set out in terms of how they're going to implement the Employment Rights Act. So a number of changes were happening straight away upon the bill getting royal assent, which was on the 18th of December. Those were pretty limited to either withdrawing, removing laws that had been put in place by previous governments to restrict trade unions. So there was nothing drastic. We've got some changes coming in February, again, around releasing restrictions on trade unions. We'll touch on that a little bit more detail shortly. April 26th, only around the corner now. It feels very close all of a sudden now that we're in January. So we'll touch on that. Some of the stuff isn't related to the Employment Rights Act. Obviously, we get national minimum wage increases, statutory rates of pay change in April. That's standard every April, but we do have those changes to sick pay coming in. We then have October 26, so we'll have just adjusted to the April changes, and then we're going to have another wave coming in about 6 months after. And then it doesn't stop there. We're going to go into 2027, which again, in December, that felt a little bit further away. Now that we're in 2026, it's only next year, isn't it? So that's the roadmap that we're looking at. So I've put these slides together kind of in order in terms of how those changes come in over that time period. So we're going to start with the sick pay one. So this is how we're going to lay out each slide. So we're going to look at what actually is the change and what does that actually mean for you. So as you probably are aware, statutory sick pay at the moment, you have to qualify for that statutory pay as an employee. So you have to earn a certain level of wages, and you also have to be off sick for 4 continuous days. The first 3 days are called waiting days. The Employment Rights Act will remove those 3 waiting days. So employees will be entitled to SSP immediately from day one of employment and from day one of sickness absence. And that lower earnings limit that meant that your lower paid employees might not qualify, or your casual workers might not qualify, that lower earnings limit will be removed. So it means effectively every worker, regardless of their earnings, regardless of length of service, regardless of how long they're off sick, all of them will be eligible for sick pay. Now, if you already pay enhanced sick pay, so you have a company sick pay policy, the impact is probably quite minimal because you're already paying more than you have to. Whereas if you generally stick to statutory sick pay rates, which is very common in small teams just because of the cost, then it probably is going to increase your cost if anybody goes off. Previously, you wouldn't have had to pay anything for the first 3 days. From April, you will. So what I would suggest is have a look back at your last maybe 12 months sickness absence records in your team. Have a look at how many days didn't warrant any sick pay and act as if that would be paid. And that's your kind of budgetary increase for the year ahead and the coming years ahead. Now, there's some people who say that this might lead to a rise in exploitation of sick pay or a rise in sickies. I don't know if that's true. Statutory sick pay is quite a low rate of pay, and that will go up, but only kind of on an inflationary level as it does already. So I don't know whether it will encourage people to take more days off sick. Time will tell. However, it is important to just know that you and your line managers can do things to proactively manage sickness absence in practice, things like having return to work interviews, proactive conversations if you suspect someone's not being genuine, and just making sure that you're measuring absence objectively. So using things like the Bradford score, things like that. If you don't know what that is, you can have a look online and there's free calculators that will help you. If you've got a staff member who's got more than 100 on a Bradford score, I suggest it's reasonable to have conversations about why they're having so much time off and making sure that you and your managers are quite confident having those conversations is going to be more beneficial going forward with these extra costs. You will also need to just update your wording in your contracts and your policies to make sure that any reference to those 3 waiting days has been removed. Obviously, you don't need to do that right now, but it's something to plan in for April. All right, so the next one, trade unions, and this is kind of going on from now onwards. There's going to be a number of restrictions. Now, the restrictions lifted. I'm not going to go into so much detail because that could take up the whole session. None of us want that. So the general principle is that the changes that are coming in will mean that unions can coordinate action, union action more easily. It also means that employees will gain a new protection that if they are taking part in union activity in any form, they'll be protected from any detriment. So they can't be dismissed, disciplined, passed over for promotion, any of those things as a result of taking part in union activity. It means there's going to be less process for unions to follow or adhere to. So that just naturally makes it easier for them to be active and to enter workplaces, recruit members. So we will just generally see more activity going on. And in my opinion, that's not necessarily a bad thing. Unions can be super helpful, especially when you're negotiating with staff, when you need to make changes across an organisation, when you've got tricky employee relations issues and there's a trade union representative present in a disciplinary hearing, for example. Those kind of things can be really helpful to have that good union representative in there. Obviously, there are some unions better than others and some representatives better than others, as there is with anything. So we'll see mixed results, I'm sure, but you will eventually, not right now and not, I don't think this year, I think it's later, I think it's earlier, sorry, in 2027, where you will have an obligation to tell staff, probably within the contract of employment, that they have a right to join a union, and we'll have to be more vocal about that with our new starters. So it will just become more of a normal thing to talk about, whereas certainly for the time that I've been doing HR consulting, we haven't seen that much activity going on with our clients with trade unions. All right, let's have a look at the next one. Fire and rehire. I don't know if anyone's come across this term. We sometimes in HR would refer to it
Emma?
as, yes?
Sorry, it's just a blank slide. We can't see any words.
Right, okay, let's have a look if I go along to the next one. Is anything up there?
No, no, no.
Okay, that's strange. Let's have a look. I'll try just stop sharing, shall I, and reshare again, just in case. Let's have a look. I love tech issues. It's brilliant, isn't it? Let's have a look. Okay, how are we now?
Yeah, all good.
Great, that's weird. Okay, just let me know if that happens again, and I'll do the same. It seems to wake it up a little bit. Um, okay, so fire and rehire. So in HR, we would often refer to this as dismissal and re-engagement. It's not necessarily applicable to a lot of small businesses. It is often something that's exploited by big businesses. There was a huge story in the news, P&O ferries a couple of years ago, and that's kind of what put this under the spotlight. It's the practice of effectively firing staff because we want to change their contract, for example, or potentially rehire people on lower salaries, on reduced hours, and that kind of thing. So businesses, sorry, would effectively terminate the contracts of those people and then rehire them or offer to rehire them with different terms and conditions. Now, it can be exploited, hence why the government are cracking down on it. But actually, it can be a really, I'm not going to say useful tool, but a necessary tool for businesses to have. Because whilst it's less common within SMEs, it can be something that we have to use. So, for example, if you move business premises, if actually there's some change in your organization that requires you to reduce hours or change shifts or any one of manner of things, and you cannot get staff to agree to that, um, what we wouldn't want you to do is push through a change and potentially breach a contract of employment because that could leave you open to risk. So what we would sometimes end up as a last resort is dismissing staff after following a fair process and consulting with them and trying to get them to agree. We would end up in a dismissal situation. We'd give notice and we would offer to rehire them on the new terms. So actually, sometimes that is a really necessary, albeit rare, situation that we come across with clients. So it's quite a concern that that won't be allowed going forward, albeit probably in practice it's not going to impact you too much. It's just knowing that that won't be an option going forward. So we'll need to just think about making our contracts flexible when we've got things like place of work written in a contract of employment, make sure we've got some flexibility in the clause to move that within a reasonable location. Things like working hours, make sure we've got flexibility built into the contracts around that, so that you're not too rigid if there ever comes a time where you need to make changes. All right, I'm hoping my slides don't go off again. Now I've switched. Let me know. So harassment. This is really a progression of changes that we've already seen happen. So if you remember back to October 24, don't know why it's always October, but it is October 24, we had a new obligation placed on all employers to take reasonable steps to prevent sexual harassment of their employees. So already you should be complying with that. That means training staff on sexual harassment so that they know what it is, training yourself and your managers on how to actually deal with harassment when it arises and how to spot it in the workplace, making sure that there's proper reporting mechanisms, making sure you've got a risk assessment. So all those things hopefully are already happening. But what the change is going to happen is that rather than employers must take reasonable steps, looks like a small change because we're going to have employers must take all reasonable steps. I think that's quite a big change, even though it's a little word added in, because all reasonable steps, we don't know what they are because we don't actually have guidance from the government which says exactly what those steps are. We're going to get that guidance in 2027, which is great because the law changes in 2026. So strange, but true. So we do need to make sure we comply with this before we actually have the guidance to tell us how to do it. There's going to be an extension as well to third party harassment, and that is quite difficult. So you will have an obligation to take all reasonable steps to prevent your staff from being sexually harassed by third parties. That means patients, members of the public, when you're out on your Christmas party, the more you think about it, the harder it gets, doesn't it? So we do need to make sure we're doing that stuff. We're training the staff. We're not just doing it once. as a tick box. We're doing it on an annual basis. Ideally, proper training, not just e-learning. I think e-learning is great for certain things and maybe as a supplementary thing. But if you can do proper interactive training where you are actually checking that the staff are engaging in that and you're documenting that they were in that training, keep your risk assessments up to date, have clear signage around your practice to make it clear to members of the public, visitors, delivery drivers, whoever it is who's coming in to the workplace, that you have a zero tolerance stance to harassment, and make it clear to employees that you will support them if anything does happen and you'll properly investigate concerns and deal with them appropriately. So it's a lot. I think it's quite a strong burden. Having said that, in HR, we're dealing a lot with grievances and disciplinaries around sexual harassment. There is a lot of it going on, sadly, and that's exactly why the law is changing and developing and putting more pressure on businesses to stop it from happening. It's just that obviously in reality, we've only got so much control over other people's behaviour, haven't we? So definitely one to watch out for and something you can definitely start doing now to prepare. All right, tribunal claim limits. So at the moment, employees or ex-employees have a 3-month time limit to bring a tribunal claim. That is a bit wishy-washy because we also have, if you've ever had the unfortunate situation of being involved in ACAS early conciliation, which is where an individual who is thinking of making a claim would go to ACAS first. It's a mandatory process. They would go to ACAS, which is the conciliation body for kind of employee relations issues. Really good organisation for what they do. They mediate, they try and resolve issues. They are just super stretched at the moment, so you don't get a lot of this time if you ever have to deal with ACAS. But that's just due to volume, unfortunately. Employees or ex-employees would go through that process of speaking to ACAS to try and resolve the issue with you, and ACAS would speak to you. That period has only just been doubled. It used to be a 6-week conciliation period. It's now 12 weeks. And then on top of that, come October, the government are doubling the time limit. So the 3-month will double to 6 months. That means if we add on the 12 weeks, because the 6-month clock does stop while the ACAS conciliation period takes place, it means in reality that's a 9-month period for somebody to bring a tribunal claim. And given what I just said about ACAS having huge volume issues, they struggle to deal with the volume of calls and cases that they have. The employment tribunal system is absolutely overwhelmed. It's never really recovered from the COVID blip. So this is already a problem and it's not happened yet. So we have claims being received by small businesses that were actually lodged by the employee 6 or 7 months ago. And it's purely administrative that there's a big backlog. The client isn't even getting to see that there's a claim. And naturally, the longer it takes for you to receive a claim, the harder it is for you to defend that. You have to start trying to find documents and data and remember what happened and what conversations took place, which is, not so difficult when it's 3 months ago. When it's potentially 9 months, 12 months ago, that becomes more difficult. It also obviously opens the window wider. So claims that would have previously been out of time because the person missed the 3-month cut-off period, well, now they've got 6 months to do it. So we've got a bigger window. It's naturally going to mean more claims, which again isn't great news for business. And I genuinely don't know how the tribunal service is going to cope. So we'll find out, but it's definitely something to be aware of just in terms of the risk. If you are doing any dismissals and things like that, just being aware that just because you haven't heard about a claim for 3 months, it doesn't mean that the issue has gone away. It hopefully does, but doesn't necessarily. Okay, so we're moving on to 2027 here. This is unfair dismissal. It's kind of the big one, I guess. Hence why the government did a little bit of a U-turn, because the day one unfair dismissal trying to bring that in, it just had so many problems, so many concerns. Again, especially for those smaller and medium-sized businesses who just don't have the resource to be going through multiple levels of disciplinary process for someone who's only worked there for one day. So quite a sigh of relief when the government did U-turn, because we think, well, at least we've got 6 months where somebody doesn't have that right to bring an unfair dismissal claim. What I'm saying on this though is it's not necessarily 6 months, because if you think about it in practice, you bring somebody into your team, there's, I'd argue, at least a month where you can't really judge the person too much unless they do something horrendous. Because they're learning, aren't they? They're settling into the team, they're learning how you do things, especially for someone who's not got experience in the sector before. So you might need to allow a month of, look, we don't count that because we're just trying to see how you go. So take that month off. If you were to need to dismiss someone before they get their unfair dismissal rights, because you need to reduce risk, you need to make a decision way before the 6 month point. You can't wait until they're at their 6 month point, because you'll end up with them tipping over the 6 month qualifying period, because you've got to remember notice periods. Even if you do immediate dismissal, you have a statutory notice period of 1 week, and that will potentially tip people over. So I would suggest think about it more as 4 months. Take the last month off, take the first month off, and think about that chunk in the middle. That's where we're going to really need to be better at, as a country, I think, assessing people, using probationary periods, nipping issues in the bud, performance issues, doing really strong inductions and onboarding to get them up to speed as quick as you can. I know all this stuff is easier said than done, by the way, when you're busy, but I think that effort will be worthwhile to reduce the risk of potentially ending someone's probation at 6 months and it tipping over that qualifying period. So this is coming in from the 1st of January. The original proposal when it was a day one right was that it wouldn't happen until October 27 at the earliest. But because now this isn't a whole rewrite of the law, this is actually just a very small amendment. We're just changing 2 years to 6 months. They've brought it forward because it's a much more straightforward legislative change. It's going to be a retrospective change. So in reality, that means anyone that you employ from the 1st of July this year, they're going to get 6 months qualifying period rather than 2 years, because as soon as the 1st of January hits, they've got their protection 6 months from their start date. So really important to tighten up on those things, probationary periods, even recruitment, before we think about probationary periods, just recruitment and making sure we're screening people as well as we possibly can. I know you don't always know and you can't always tell, despite the best interview skills and tests and all that stuff, but tightening all that stuff up will really help to better assess. And that has knock-on effects anyway. The cost of recruiting the wrong person is already high, and obviously could get even higher with this risk added on. All right, 0 hour and agency contracts. Again, I'm not sure how many of you use these types of contracts, but super flexible arrangements. Again, the initial proposal from government was to ban all 0 hours contracts. It's quite a dramatic headline. And again, there's been backpedaling going on, which again is a good thing, because 0 hour contracts, casual contracts, really have a place in the workplace. My background was in the care sector. We relied heavily, and organisations in many sectors still do, on having those kind of banks of staff who you can call on at short notice, who can step in and help. So the good news is there's no banning of 0 hours contracts. It's just about banning the exploitative types of contracts. So effectively, the government's trying to remove one-sided flexibility, make sure that any 0 hours and casual agency contracts are managed well and balanced. I mean, most people, in my opinion, who are on one of these contracts are doing so out of choice. I think, yes, there are some bigger companies who potentially exploit, but generally people are happy on these types of arrangements. That's just from what we see, but I think this change isn't necessarily a bad thing in principle, but it does create a lot of admin. It means that if you do have anyone on 0 hour casual agency contracts, they're going to have a right to guaranteed hours following a reference period, which we imagine is going to be 12 weeks. So it means every 12 weeks, you'd be looking at what that person has worked. Maybe they've averaged 10 hours a week. You have to offer them a 10 hours a week contract. Obviously, there's an admin side to that, which is a bit burdensome, but there's also the fact of seasonal work. Sometimes we have people who are coming in for a set period because there's a need at that time. It could be covering busy, like holiday periods where there's a lot of permanent staff off on leave. And if you reference that 12-week period, it's not really representative of what they would normally work. So I do have a few concerns about this, but it does mean that we have an opportunity to review actually whether casual and 0 hours and agency contracts are the right type of contract for you to be using. There's lots of things we can do with permanent contracts to make sure you've still got that flexibility. Things like annualized hours contracts, where you're not saying that you're giving someone so many hours a week, so many hours a month. You're saying you'll give them so many hours a year. So it means you've still got that flex throughout the months to offer more or less hours. So lots of kind of creative ways we can make that work if you've got those types of agreements in place at the moment. But that isn't till 2027, so you have a bit of time yet. Okay, bereavement leave. So at the moment, no right to bereavement leave unless the bereavement is a child or if it's an employee who loses a pregnancy past 24 weeks. So the law will change in 2027 to mean that everybody will qualify, every employee will qualify for 1 week, we think, unpaid bereavement leave. That includes an employee who loses a pregnancy at any stage prior to 24 weeks. After that, the current position would stay the same, which is statutory parental bereavement leave. So that is a statutory paid leave. So this is in addition to, not to replace that. We don't yet know who this applies to, and this is what I'm quite interested to find out. So bereavement leave is always quite subjective. We always have conversations with clients about in policy writing, like who should cover in the policy. Is it immediate family members? Well, we don't all have traditional family environments anymore. Some people would say that it should cover friends. Maybe it should cover extended family, and that's a problem because you want to be fair, but equally it's where do you draw the line? So it'll be interesting to see what the consultation on this brings out, and we will all find out together because we've got no news on that at the moment. But again, this one isn't till 2027, and it might be that in your policies you already do this, in which case you don't need to do anything else. It's just keeping an eye on the change and making sure that when the change does come in, that your policy doesn't go under what this law will say. So those are the detailed bits. I then just wanted to run through some other stuff, which is of note. There's just less detail I can give you at the moment. There's a lot of detail that just isn't here. So introduction of the Fair Work Agency, and this is an April 26 change. So it's happening soon. So the Fair Work Agency is a brand new regulatory body that's going to be introduced to enforce employment rights. So at the moment there is no body doing that, as in no body, not person. There's no statutory body, regulatory body for enforcing employment rights. It relies on an employee to go to a tribunal for employment rights to be enforced. So this will be a brand new agency. They will be tasked with making sure businesses are complying with employment rights. One of the worrying things is that they will be able to bring tribunal claims on behalf of employees. So even if an employee didn't want to bring a claim, this agency will be able to do it for them. They'll be able to enforce national minimum wage compliance, enter workplaces and demand documents and investigate and all that kind of stuff. So similar to other regulatory bodies, I'm hoping that there's a kind of an employer-friendly approach to this, in that, like data protection, if you've ever had to ring the Information Commissioner's Office for data protection issues, I've always found them super helpful. They want businesses to succeed in enforcing data protection rights. They're not there to kind of beat everybody with a stick who gets it wrong. It's very much helping businesses to learn how to comply. And I'm hoping that that's what the Fair Work Agency will be doing as well. But we will have more detail. I think what we'll see in April is very much a skeleton form of this agency because there's just way too much to do to get that up and running in its full capacity by April when it actually currently doesn't exist. So watch this space on that one. We then have day one paternity and parental leave rights. So at the moment, these are rights that require 26 weeks qualifying service. So it's just shifting that to a day one right. It's nothing significant. It's more of a very small policy change. There's going to be more changes to flexible working regulations. The headline is that flexible working will become the default. That's not really what it is. It's just shifting the focus. So when an employee puts in a flexible working request, you've already got the requirement to handle that request appropriately and follow a process to consider it. But rather than actually looking at a request in terms of how you can decline it, we want to shift the focus to how can we accommodate it? How can we promote flexibility in the workplace? How can we preempt flexibility? And how can we accommodate as much as we possibly can? You'll still, though, have the right to refuse a request. So that part isn't changing. So if you cannot accommodate a request to go part-time or a request to work from home, you'll still be able to refuse for a reasonable business reason. You'll just need to evidence that reason a bit more clearly under the new, or not new law, changed law. There's going to be enhanced protections coming in for pregnant workers and employees on maternity leave. Again, there was already individuals who have quite a lot of protection in the workplace, so it's kind of just extending that further. It's nothing necessarily new, just enhancing additional protections. And then a bit of a niche one here, which is around collective redundancy. This is where collective redundancy applies where we're making or proposing to make 20 or more people redundant within a 90-day period. So it's not as relevant to the small businesses that we work with, but just important to note if it does apply to you or any of your businesses in the future, there's going to be new thresholds for actually triggering collective consultation rules and a doubling of the protective award. That's the award that is given by a tribunal if a business fails to comply with collective consultation rules. So that's going to be a staggered change through April and October 26. All right, I'm just looking at my clock and making sure I'm not keeping you longer than I need to. All right, so really the important stuff is about actually what can we do though? How can we get a bit prepared for all this stuff that's coming in? Because it is a lot. I appreciate it's a lot. And we always knew it was going to be a lot with when this government came in. So the more important thing is, but it's coming anyway. So we may as well get prepared so that when it does come, it's not a bolt out of the blue and we're not prepared at all. So as I mentioned earlier, recruitment is already important, obviously. It's already an absolute nightmare if you've ever recruited the wrong person, the time it's taken, the effort you put in, the money you spend, and then you're back to square one because it doesn't work out. So this is a good opportunity to review your hiring processes. Make sure you're doing the best you possibly can to screen people out. We see a lot of kind of panic hiring where there's not maybe as much planning gone into the recruitment process as possibly could have done, and that's normally just due to time constraints. But I think actually putting more time into recruitment, making sure we've actually got really good job descriptions, really good person specifications, really good ways to screen, ask really good questions in your interviews, focus on values, ask kind of values-based questions so you know you're getting the right kind of fit for your culture. I'm sure we've all experienced that thing where the person is skilled enough, got the right qualifications, but the fit is really off, and that can be more damaging than a lot of things. So how can we actually test that in people before we hire them? Maybe getting more of your colleagues and team members involved in recruitment so that you're getting different opinions, and just really put some effort into refining that, because knowing that when we get people in, we've only got that 6-month period to actually assess them. It's going to be much easier to do that if you've hired the right people in the first place. Absences, obviously, we're going to have that change to sick pay. So tracking absence is really important. Make sure we can easily spot patterns. those people who like a Monday off, those people who like the day off after a holiday, those kind of things. Just keep track of that and use a good system to monitor. A lot of these systems now do it for you. So if you can do that even easier because it doesn't take up any more of your time. But also make sure that you're not worried about having conversations about absence. You do have the right to ask questions if you have reason to believe that someone's either not being genuine or that you've got actual concern about their well-being. You're asking from a reasonable perspective. You're not just being nosy. It's important that you've got a duty of care to your staff. You want to know that they're okay, but also you want to know if they're being genuine when they do ring in sick. So make sure you've just got processes that everybody has to follow. If they don't follow it, you address it and deal with it and don't just let it slip, because that's where we see absence become just a habit rather than something that's used genuinely. A number of the things I've said today will impact contracts, so sick pay, for example, but also things like I mentioned, the 0 hours contracts and using more flexible types of arrangements that are not 0 hours, but they've still got the flexibility in there. So think about your contracts, have a review of what you've got already, and just check that they're actually still fit for what you need as a business. And then 3 more things, training. So I already mentioned the sexual harassment training, that should already be happening, but also just training if you've got other line managers who are doing the people management in your practice, just see about how can we make sure that they are upskilled, that they know what these changes are, they know what they can say to team members, because a lot of the time when we speak to line managers, it's a case of not knowing actually what can they ask, what can they question, what can they say to staff, especially where we've got challenges going on. So that training and investing in your managers is really important. Thorough review of policies. A lot of the stuff, again, is going to change your policies, not probably drastically, but it's certainly going to be tweaks. Make sure your policies are not slipping from compliance, because there's a lot of changes coming in. It's very easy at the moment for policies to get out of date. But again, it's not just about compliance, it's making sure that they are right for you as well. So they're not just stock policies that you've inherited. If you have done that, review them and make sure they work for you, because that's the most important thing. And budgets, obviously, some of these things have costs associated, the sick pay change, potentially having to implement training. There is cost there. So just make sure that you're aware of what that is and it's factored in so that you're not getting those surprises along the way. And if you do need any HR support or you have existing HR support, these are the kind of things you should be asking for. Updates to handbooks and policies and contracts as and when required. These are the kinds of things we would do for clients automatically. Making sure that your HR team or your outsourced HR team is providing training for you, giving you the employment law updates, offering e-learning as basic compliance, offering in-person training, making sure that your team are prepared, that your managers are prepared, and that you are prepared as well. Risk assessments, so the sexual harassment risk assessments we talked about, really important. HR audits, it's a good time. We're quite busy with this kind of thing at the moment. So actually just doing full audits of HR processes, practices, management practices in particular, the systems that are being used, just to kind of check, is everything actually fit for purpose? And if not, let's get it there before these things start coming in and hammering us. So just making sure that everything is as easy as it can be. Probation and performance and absence management support. So those kind of tricky areas where you might need to have difficult conversations, or you might need to do dismissals, you might need to issue warnings. We can help with that. If you just want to talk through, how do I actually approach this situation? How do I talk to this staff member? It's not always about the legal compliance. It's just sometimes I don't know how to say it. I don't know how to say it to get the best result out of the conversation. And sometimes just talking it through with HR can be really helpful. And actually on the more strategic level, thinking about if you're aiming for growth, whether it's through people, whether it's through tech, which will potentially drive efficiencies. We do lots of that as well, and look at how that impacts your people, how that impacts your training across your business, how you might need to plan for what's happening in a few years' time, not just the bits we've talked about here, but the bigger picture stuff we can help with as well. And of course, advice and guidance on the changes, as I've just talked about. And one of the things we do, which you might already get through your current HR provider, but employment tribunal insurance is a core part of what we do, giving our clients that peace of mind that actually we can't avoid tribunal claims. I wish we could. We're pretty good at HR. We're pretty good at HR advice. We've done it a long time. And even with that, we do unfortunately still get clients receiving tribunal claims, which is why we offer some really good insurance, which means if that does happen, the client has the peace of mind of knowing they've not got legal bills then to start defending a claim. They can just hand it to us and it's all dealt with. So if you haven't got those kinds of options for support at the moment, you've now got our details, or you will have on the next slide, and you can get in touch. My light keeps going off and I end up stood in the dark. So there we are again. But that's it. What I've put on the screen here, I'm assuming my slides are still showing as they should do. What I've popped on the screen here is a QR code, which takes you to a free quiz. It's kind of linked, well, I say kind of very strongly linked to what I've just talked about. It's a free quiz purely focused on the Employment Rights Act implementation. It will help you understand how prepared you currently are for the changes, and it will highlight for you any areas that you really maybe should focus on over the coming months. And we're all about that. We're trying to get our clients and people that we know prepared. We don't want people to be frightened or panicked. We just want everyone to come along with the changes, not be swept along by them. And that's it from me. I think we've got about 10 minutes left, so I'd be interested if there's any questions or anything I can help with while I'm still here.
Right. Thank you, Emma. That's been great. Really insightful.
No
Thank you
problem
very
at
much
all.
for your time. So if anyone has any question or comment or would like to, hi Carmen.
I have a question. When you say that working flexible, I have one of for my dental nurses. She's constantly being late due to childcare. You know, like nurseries, they open very late by the time we change and everything. And it's starting to affect the rest of the team. I don't have an issue with her because I always put her as a spare. But the rest of the team, they feel like she's getting preferential. But
It's difficult. Yeah,
yeah,
it is. It's difficult. And there are a number of rights that people have when it comes to childcare, and we've talked about emergency dependence leave, but that's more if, the nursery's closed all of a sudden, or the child's not well and employee needs to go and look after them. That shouldn't really be used for regular, because that's then no longer emergency. That's more just nursery.
yeah, it's routinely 10 minutes late in the morning.
Yeah, and it might be worth a conversation. I mean, whether it's even, we have had this before where clients have then agreed actually that start time just isn't going to work, and we've just had to agree a different start time for that person, which kind of takes the difficulty with the other colleagues, because you can say, look, that's actually now not their start time, so they're not late. That's just now how they start. And I know it's not the best solution, but if it's a
Yeah,
constant battle.
yeah, but then she said that I'm gonna lose hours, you know.
Yeah, I know. And it's difficult. And it might come to that point where you've got to say, well, it's either you attend on time or we can start time, and it's got to be one or the other.
Thank
Difficult though.
you.
I do empathize.
Thank you so much.
No problem. Thank you for the question.
Thank you, Carmen. I don't know if anyone else have any questions or comments. No, I don't think so. Well, that will be all for tonight. Thank you very much, Emma. Thank you, Carmen, and everyone who's been online. We will share this session also with people that have attended. So stay tuned and thank you so much for your time. Have a good evening.
Thank you, everyone.
Thank you.
Bye-bye.
Bye.